Good afternoon, everybody. My name is Mark Hansen. I'm Interim Director at the Practical Ethics Center, and I want to welcome you to another of the Practical Ethics Center series PEC Presents. Before I introduce today's speaker, I just want to let you all know 2 weeks from today will be our next speaker, Dr. Herbert Swick, who's Executive Director of the Institute of Medicine and Humanities, who will be speaking on the topic Selfish or Selfless? Physicians Confront Epidemics. And I would welcome you all to attend. Our series continues every other Monday at this time. We also have flyers and a sign-up sheet afterwards if you're interested. Today I'm very pleased to have with us Karen Townsend, who is the Chief Deputy County Attorney in the County Attorney's Office here for Missoula County. Just a word about her background. She's also a Special Assistant United States Attorney, attended Ohio Wesleyan University and University of California, but is a law graduate right here from the University of Montana. Has a number of memberships and distinguished organizations, obviously a fellow of the American College of Trial Board Lawyers, the American Bar Association, State Bar of Montana, National District Attorneys Association, Montana Supreme Court Commission on Criminal Jury Instructions, former Chief Staff Attorney, County Prosecutor Services Bureau, Montana Department of Justice, former Director of Training in the National College of District Attorneys, in addition to extensive local, state, and national trial advocacy teaching experience. She's also demonstrating ethics in the area of community activities through involvement in organizations such as Big Brothers Big Sisters and Kiwanis Club, YWCA, Western Montana Bar Association, Board of Directors, and the Advisory Board of St. Patrick Hospital. So, again, pleased to have Karen with us to speak with us today about being a zealous advocate and still doing justice. Karen.
Thank you. It's my pleasure to be here. Let me just get started. How many of you folks are lawyers or law students right now? Can I see the hands? Okay. How many of you are thinking about maybe law is sort of someplace where you might want to go? Okay. And how many of you are just intrigued with the idea that lawyers have ethics? Well, what I want to talk a little bit about is to try and give some background about what we mean when we're talking about ethics for lawyers. I want to talk to you somewhat of where our standards have come from, what the consequences are when we don't follow these standards. And then I thought at the end of the presentation I'd talk a little bit about how these issues really get bound up in trying to make everyday decisions, okay, as a prosecutor. It's really correct that lawyers are governed by all kinds of rules that say what we can and can't do when we're presenting our cases. Now, some of these rules come from the Constitution, okay? Some of them come from state constitutions, some of them come from state statutes, and then some of them come from our cases that are decided. These are issues that lawyers, no matter what side they are representing in a case, have got to follow. And if they don't, okay, they get in trouble. There are also other places where our standards come from. Okay. And these kinds of standards come from the organizations, okay, that attempt to govern lawyer behavior. The organizations, the most prominent one is the American Bar Association. And that particular organization a really long time ago got together and decided we ought to have some rules, we ought to have some standards that govern what lawyers can do. And so in its most recent evolution, the set of standards that are called now that govern lawyers' behavior are called the Model Rules of Professional Conduct. Those rules are then passed on. And now the American Bar Association has no governing power over any lawyer. Okay? They're just a group, an organization made up of lawyers. But they do have a bunch of commissions and groups that get together and do things, and this is one of the things they did. Promulgate these model rules. The rules then go to the individual states for adoption. And in Montana, the organization that adopts the model rules or the ethics rules that govern all our behavior is the Montana Supreme Court. And the Montana Supreme Court adopted the model rules of professional conduct on June 6th of 1985. So the rules that govern Montana have been around for quite a long time. For not quite all of my professional career, but a good chunk of my professional career. Now the ABA has not stopped at the model rules that we adopted back in 1985. In 2002, they have a continuing group that keeps looking at the rules to see if we need any changes. And they have revised the model rules, but those revisions have not yet been adopted by Montana. So we're still governed by the rules that were adopted in 1985. Now you also see up here that there are a couple of other organizations that have some input, okay? And one is the American Bar Association that developed, in addition to these rules of ethics, a series of standards that govern criminal cases. And so those are the standards for the prosecution and the defense function. Those don't really ever have a force of law, but they are in fact quoted on many times by courts when they think that somebody has screwed up, okay, and they're trying to decide what to do about a case. And then finally, the National District Attorneys Association, which is a voluntary association made up of prosecutors from all around the country, has also adopted a series of standards for the prosecution. Again, those are recommendations only. They are aspirations in some ways, although they do track the ethical rules, and they have no force of law. So what happens if you don't do what you're supposed to do? All right? There's some bad things that can happen, right? You can get the judge to yell at you in trial when you screw up, okay? That's a rebuke. You can get a mistrial, which means you got to start over, all right? You can get the case dismissed. If you haven't done what you're supposed to do, the judge can just throw your case right out of court and you're stuck. You can't proceed anymore in a situation like that. You can be sanctioned sometimes by the judge. He can fine you or send you to jail, okay, for contempt as far as not doing it. And then the case may go all the way through, and at the Supreme Court level, it's reversed because you have not followed what you're supposed to do. And you might be subjected to civil liability. So somebody can sue you, okay? Maybe the person you were prosecuting in this case can sue you for not doing it right. Or in some cases, you might even be subjected to criminal liability. So there are really some serious, serious consequences if you don't follow the rules. In Montana, the Supreme Court is the ultimate authority on lawyer discipline. They're the ones that decide what happens to a lawyer if there is a complaint that says the lawyer hasn't followed the rules. Discipline can range from a private reprimand, okay, they send a letter to the lawyer and they say, naughty, naughty, don't do it again, right? Up to active disbarment forever, okay, so that a situation can, depending on how serious it is, those are the consequences of why you have to follow the rules. In Montana now, there is an employee of the State Bar of Montana, which is an organization that every single lawyer who practices in Montana must belong to, called the Discipline Council. And this Discipline Council is a lawyer who works for the State Bar, who is in charge of investigating allegations of misconduct. So if you, for example, were represented by a lawyer and you think a lawyer has violated some of the terms of ethics, you can write a complaint to this, and it goes to this Discipline Council for preliminary investigation. What happens then is that the Discipline Council writes to the lawyer who's accused and says, so-and-so has said such and such about you. What's your response? Okay? And so then you must, in turn, feedback in written form to the Discipline Council about what you say happened. Okay? Whether or not you agree, disagree, contest the complaint that is being made. Discipline Council can then refer, if they decide there's like probable cause, to the Commission on Practice. And the Commission on Practice is a group, essentially a group of lawyers and non-lawyers chosen by the Montana Supreme Court to hear evidence on cases of misconduct, lawyer misconduct, or you're violating the rules of ethics. They then make findings and recommendations to the Montana Supreme Court about what should happen to a lawyer if they find that there's been a violation. And then finally, it's up to the Supreme Court to decide, yes, we're going to go along with them, or no, we're not. We're going to do something else instead. It is often the case that when it gets to a hearing like this, some lawyer in the state of Montana is appointed to act as the prosecutor for the commission, okay, to present the evidence, okay, because the accused lawyer is entitled to be represented as well, but they have to retain their own lawyer in a situation like that. Okay, so why else do you follow the rules? Well, it's because basically it's the right thing to do, of course. You know, it's not just, I only do this because they tell me I'm supposed to. I do this because this is what you're supposed to do. Do I recognize that there are people who don't follow these rules and they think if they can get around it, of course, okay, that happens. I hope, fortunately, it's a very small percentage of people that happens to. But it does happen, and we, of course, have had a very recent case, okay, that has been decided by the United States Supreme Court in the death penalty was just overturned, okay, that involved prosecutors not doing what they were supposed to do in that case, which was turning over evidence to the defense about information about their own witnesses. So, yes, there are serious consequences, and that's a case that went on for 18 or 19 years with a guy on death row, okay, about what might happen. So, you do it because it's the right thing to do. But I think it's important for us to remember that if you're, as a prosecutor, just because you're ethical, just because you're following the rules, doesn't mean you have to be a wimp. It doesn't mean you have to roll over and play dead every time somebody asks you something. You have to remember that the prosecutor carries that sort of justice as well. Now, and so that's what you are allowed to use. Now, prosecutors are expected to follow all of the model rules, although clearly there's some that don't apply to us. You know, like billing, right, fees, getting out of a case if that's what you're supposed to do. I mean, all of those sorts of things don't apply to me at all. But there is a rule that applies to prosecutors and applies to no other lawyers, and that's what I want to talk a little bit about now. And why do we have this particular rule? Well, part of it comes from a Supreme Court case way back in 1935. And this was a case called Berger versus U.S. And basically, you can see that they were talking that there weren't any lady prosecutors when they wrote this case, because they're talking he's. But it is a situation where they say, you can strike hard blows, you can't strike foul ones. It is your job, okay, to refrain from improper methods calculated to produce a wrongful connection or conviction, just as it is your job to use every legitimate means to bring about a just one. So why is it that we have those special limitations on us as people who represent and come in and act as prosecutors? Well, primarily it's because we have a lot of power. Okay. It is my job, basically, to decide who should be charged with crimes and what crimes they should be charged with. And it's not just a situation where I have to willy-nilly take what the police or a crime victim brings to me. It's my job to make that independent decision about whether or not we should proceed with the charge. Now, these decisions are always tied to complaints by victims or investigations from law enforcement, but ultimately it's my job to make that final decision. Once a person has been charged with a crime, the prosecutor does not represent that individual victim. It's my job, our job, to represent the interests of society in general, trying to ensure that people who have committed crimes are held accountable. If a person wants independent representation, they want to sue the person for damages, they get a private lawyer. So that's why I can't let the victim run the case okay? I can't let the police run the case. It has to be my independent decision about how we go forward. So, and we know that the consequences for somebody charged with a crime are severe. You face potential loss of liberty, money, reputation, and in some cases your life. And so because there's that much power that is exercised by people who are prosecutors, we have to have this special rule, which is Rule 3.8. So let's look a little bit about what are some of the things that 3.8 talks about. The first one is refraining from prosecuting a charge the prosecutor knows is not supported by probable cause. Now, that sounds pretty easy. Probable cause basically means that it's probably true that this person committed this crime. So it's not a very high standard, but you must at least have that kind of a standard before you file charges. And if so, it's not right to just file a charge against someone because you don't like them, right? You know, well, I'm going to dredge up something, okay? You got to have evidence, okay, that will allow you to file this charge. Now, it can be sometimes cases that the evidence may not ultimately get into the court, okay? That affects you down the way. But at least you got it initially. It says there is enough evidence here to charge John Doe with this particular crime. He stole this money from such and such. We're going to charge him with that kind of crime. Number 2 here, number B, is make reasonable efforts to make sure that the person knows he's got a right to a lawyer, okay, and can get a lawyer if the person wants one. So you're not allowed, the system works here basically, theoretically, is that there are 2 lawyers of equal competence on each side that make sure that justice turns out. I mean, that's the theory. And so it isn't right if we run roughshod over somebody who doesn't have a lawyer, and that you don't help them understand that they have a lawyer. Now, generally, there's not too much trouble here because the judges are also charged with making sure that these sorts of things happen. But if for some reason you have a judge that's not doing it, it's your obligation as a prosecutor to make sure they get a lawyer if they want one. Number 3, not to seek or obtain from an unrepresented person a waiver of important rights. Okay, so you don't go if someone has decided, no, I don't think I want a lawyer, I want to represent myself, okay? And first of all, we discourage that, but secondly, if they insist on it, then you're not allowed to try and have them give up important rights. Now, what they talk about here is a preliminary hearing. That's an initial testing of the evidence to make sure that there's probable cause. But there are other things that might come up. Now I want to talk about subsection D, which is the one that probably is the most different for us than it is for anybody else who's a lawyer. And that is to make timely disclosure to the defense of all evidence or information known that tends to negate the guilt of the accused or mitigates the offense, and in connection with sentencing disclose to the defense and the tribunal all unprivileged mitigating information. Okay, so what exactly does that mean? It means that I must turn over to the defense anything and everything that hurts my case. Okay? I may learn in the course of my investigation or review of the evidence, or maybe in talking with the witnesses, okay, that something is not quite like it's used to seem from the police reports. For example, maybe I'm prosecuting a domestic violence case, and this happened just the other day, okay? And the victim comes in to meet with me and tells me that she didn't tell the police the truth about what happened. The night of the arrest, she says that he beat her badly and these bruises around her face were caused by him. Now she's coming in and she's saying, no, that's not really what happened. I tripped and fell and hit my face on the stairs. Okay? I have an obligation to turn that over to the defense right away, even if I believe, and with good, even if I have good reason to believe that she's not telling me the truth about that's what happened. Okay? That I honestly believe that she's just recanting here because she wants to get back. Okay? And so the only way she figures out she can do it is to come in and say that she lied. If you determine that the recantation is really the truth, then your obligation is to dismiss. It's not to just not just tell the defense and say, okay, well, we're going to fight it out anyway and see what happens, because then you no longer have probable cause to support the charges. Now, this is where we differ from those who represent criminal defendants. If the criminal defendant were to tell his lawyer or her lawyer that he had really beaten her badly and he did it on purpose, okay, in a conversation that the accused and the lawyer might have, that lawyer doesn't have to tell me, okay? That's a privileged conversation, and they do not have to tell me, even though it hurts their case, okay? For example, now the defense attorney cannot knowingly put that client on the stand to say something different, okay? But they don't have to tell me that he said in a meeting with me, I really beat her, I did it on purpose, and boy, I'd do it again if I got out of here, right? I mean, that kind of a situation. For example, maybe the criminal defense attorney has thought that maybe there's a psychological defense here. And so they arrange for their client to be interviewed or evaluated by a psychologist. And the psychologist comes back and tells the defense attorney, there's no defense here. You know, and besides, this guy's a really dangerous son of a gun, and that's what my opinions are. And he made all kinds of admissions to me about what he had done in the course of the evaluation. The criminal defense attorney does not have to tell me that. All he does is say, no mental defense here. I don't have to turn that evaluation over. And so that information is not disclosed. And they are allowed to do that, okay? But if the contrary were the case, if I had arranged for a mental evaluation under some theory that I was allowed to do it, usually you can't, but maybe there's some way you can do it. And our psychologist said things that really helped the defense didn't help me. That report must be disclosed, even if I'm not going to call that person as a witness. So this is an attempt to try and make sure that the defense gets everything that they need to assist them. And this is sometimes where prosecutors get in trouble, not always on their own because of themselves, but because they are charged with also turning over anything that their investigators have. And so if the police or the sheriff's department or some other investigator that works for them is hiding the ball on purpose and not giving stuff to the prosecutor, and it's later discovered, we are still as responsible for that. Okay, so it is an attempt to make certain that the other side has everything that they're entitled to. So how do you comply with all these rules and still be a zealous advocate? Well, you strike those hard blows. You don't strike the foul ones. It's clearly an appropriate situation to hold people accountable for their criminal behavior in society. So what do? You charge what you can prove, okay? You look at what is there. You don't overcharge with the hopes that a person will plead to something less. Or you don't charge because you think, well, this guy's done a lot of bad stuff. Maybe you don't have a lot of evidence here, but boy, he's gotten away with all this other stuff. That's not legitimate. You review all the evidence, including anything that is given to you by the defense. Sometimes the defense will bring evidence to the prosecution saying, I want you to look at this stuff and maybe you'll change your mind. And you're not grudging when you look at that. You go ahead and accept it and you give it the appropriate weight it deserves. You accept without griping that these rules are designed to make the system work. So you don't try and grudgingly comply. You do it as best you can. And then you present your case with all the skill and persuasive ability you've got. Okay? You argue strongly for appropriate sanctions. You admit when you screw up. And even if it means that the case must be tried anew or the charges dismissed. Those are our obligations. So let me ask you now, and maybe we can engage in a little discussion at this point about where exactly the dilemmas come in. How many of you think that we should charge an individual or individuals who have seriously injured a man who they believe molested their daughter? Any hands? Okay, why do you think that?
To not do it would encourage vigilantism.
Okay, all right. So, so what kinds of standards do you think that I should use in making that kind of a decision?
In be normal standards for assault.
Okay? So if it's assault or more serious charges, as long as the evidence supports it, it's okay. Where do you think I should consider what I would call mitigating factors? Let's assume that it's true, okay, that this guy's a bad guy, okay, he's a pervert, okay, but we should, how do we take account of that in judging what the appropriate charges and/or sanctions are for the people who commit the injury?
Well, I'm not sure about the charges, but I would think the judge would sanction the individuals.
Okay?
And perhaps you as prosecutor should also charge the person who was assaulted.
Okay? All right? All right. Does anybody disagree? How many of you think that that's a hard position? How many of you think a jury is going to find those people guilty for doing the bad thing to a guy who has actually molested their daughter? Yes?
Can you apply, for instance, the same standards that apply to homicide, such as first degree, second degree, third degree, or whatever terminology is used for that now? In other words, balance and forethought with the heat of passion and/or the third being accident.
Okay. In Montana now, we have what we call deliberate homicide, mitigated deliberate homicide, and then negligent homicide. So that's kind of the way our standards are now. And so do I understand that you're suggesting that perhaps we would, instead of doing the
Assault.
deliberate, we
Apply
might
that same-
move it down?
Apply that same terminology to assault. Deliberate, mitigated,
Okay? Yes?
Well, I would think it's not your job to second guess the jury. If
Okay.
they want to let him go, then that's their prerogative.
That's the position that I've always taken, is that if as long as I feel I've got a legitimate case here, and I know I would recognize that this would be a very difficult case because people may say, well, yeah, we think they did it, but, right? Okay, we're gonna let them go because we don't like child molesters, right? Okay, I think that is, as long as you can go forward and say, I'm not cheating on the evidence, I'm presenting it as well and as strongly as I want, and I can argue exactly for vigilantism. I mean, I think that's part of the argument that I would want to make in a case like that, is the fact that we must have the law hold people accountable, not individual vigilante justice, but recognizing that they might kick them loose, and that's what you have to do. What about dismissing charges when the domestic violence victim comes to you and says, I didn't tell you the truth, and you've got pictures, that show her really severely abused. You even have overheard comments from the police who arrived showing that this guy was really striking her. We hear the blows from outside, but the victim now comes in and says, I tripped and I fell. What do you think we ought to do with those cases?
You got to try it anyway.
You have to try it.
Well, otherwise, there's so many reasons that people might be can't. And if you just let everybody get off the hook, then as soon as somebody bonds out, the intimidation factor goes up a huge amount. And lots of people come in and recant already. You can only imagine how many it would be if that was an automatic dismissal of the case.
Well, and I think that sometimes, it sure has been my experience that most people think, well, it's my choice to make whether the charge goes forward or not. And that's part of the role as well of a prosecutor, is that you have to make that independent decision. Now, so as long as you've got legitimate evidence that you can go through, and again, the person might get off, but it's the jury that's making that decision, the so-called conscience of the community. All right, here's another one. So you have a situation where you've gone to trial and you convicted a man of rape involving his 12-year-old daughter. It is now 10 years later, okay? The person at that point never appealed. In fact, the person went into an agreement and got in trouble again after they had decided to, after they had given notice of appeal, they got in trouble with a dead bang conviction case, okay? On videotape, breaking into an office. So an agreement is reached where we'll withdraw the appeal on the sex case, plead guilty to the burglary case, get a concurrent sentence, okay, and out. Now we have 8 years later, the daughter has come and has said, I lied, my mom made me do it. What do you think we ought to do with that case? Yes?
We've got the burglary case, and that's clear cut.
Well, it's done. I mean, you know, the guy has,
Served the time.
right, and the situation here is that one of the things that was given up in the burglary case was the ability to have this guy have a much longer sentence. Okay, so you, as the prosecutor, gave that up, okay? So a shorter sentence, even though the guy was eligible for a substantially longer sentence, so he's got the benefit of that bargain. And now you have this 21-year-old coming and saying, I didn't tell the truth, and I missed my dad, and I want to get back with my dad. So
She
what?
could still be recanted.
Right.
I mean, something could actually happen.
Okay? So part of what you want to do is say, is evaluate it to see whether you think maybe we don't have, the second statement is not a truthful statement, the original one really is. Those are hard calls to make, but they're things that we have to do. What sort of things do you think we ought to, what should I mean, this is the case I've got right now, what should I be looking for? What do you guys recommend?
Release that information to him or to his lawyers so that they can decide whether, is that grounds for a retrial?
Well, the lawyers have brought this, his lawyers have brought the information to me, okay? And so they specifically are petitioning now for a new trial on the grounds of newly discovered evidence. That's the posture of the case right now. And I have taken the position that I'm not so sure I believe the new statement, right? You think, I mean, how many of you think that's a legitimate position for me to take? Or should I just go try it again and see what happens? Why do you think that?
I think you should be wary of the statement.
Wary of the new statement?
Yeah, I think you should, it should be highly scrutinized before there's a new trial. This wasn't there. You said the first one where he was charged predominantly for the burglary.
But actually, he had two separate cases. The first one was the rape case, okay? And the jury convicted. He then appealed on he made some arguments about some issues that might go to appeal. And he was out of jail pending that appeal. While he was out of jail, he gets in trouble 4, 5, 6 months later, okay? Before there's a decision by the Supreme Court, okay, on his appeal, with the burglary where he's caught on video, right? Okay, so I mean, it's like an easy case, right? Okay. So then, we revoked his release, okay, and because he was out, because he was supposed to be a good boy. So he went to jail, went to prison immediately on his rape case, and the rest of that deal was crafted. And now we have the daughter who has come forward about a year ago, after she's 21 and 22, saying that basically her mother made her say these things. Okay, at the trial. Yes?
I'm just curious about the context of the rape allegations, whether or not it involved a custody battle in a family dissolution, and whether or not there was a rape kit and DNA evidence.
Okay. There was no rape kit or DNA evidence because it was a late report. The mother and father were divorced at the time. And the daughter was here in Missoula visiting for a summer visitation, okay? When she went back about a month after she returned to her home, she disclosed first to a sister, then was taken to a sex assault clinic in Washington. And so, but it was too late. I mean, there was no medical findings of any kind, too late to find any kind of DNA. And the defense all along has been, never happened. Okay, all right, so never happened. That's been the defense all along. So that's kind of the situation that we've got, that she was interviewed by a doc well-trained in sexual assault investigation, separate from her mother, interviewed by the cops, separate from her mother, testify without her mother present. I mean, so all of those sorts of things are we try to, we always have to be careful about those kinds of cases. You're right. That's something that you have to consider. And now Mom wants nothing to do with her. And so part of my thought is she wants family. She wants me. And that's one of the things that's happening.
How much of his sentence is left?
He's got more suspended time, but no more prison time.
So he's out regardless?
He's out.
So the only thing that's really the question is whether or not you can keep him on parole.
Well, keep him under that and also force him to register as a sex offender. I mean, that's the one thing that's still, the one thing that's hanging over his head now is that he's required to register as a sex offender.
Was it his own daughter or stepdaughter?
His own daughter. And there was some corroborating evidence. The little brother basically saw them in bed together, right? Okay, but that's, we have that kind of information. So,
I guess I'd be inclined to say go ahead and dismiss it just in a matter of conservation of resources. I mean, he's out. As long as there's not a history of this, there's not really any particular, you're not going to put him back in jail anyway, he's already served his time.
he's already
So
served
the
his
only
time.
thing you're arguing about is whether or not you have to pay the money to supervise his parole and make him register for the sex.
Well, he has to be supervised anyway because of the burglary case. Right,
Yeah.
so it's an extra cost on the public in
Well,
terms.
except that if you have to retry the case, it's a huge extra cost.
That's right, there is that.
But every place he moves, he goes with that notification stuff.
Exactly, there is that.
Always loves him with that.
So is the basic question just for your own conscience, that if you were to commit another sex offense and you did decide to dismiss, is that kind of your dilemma that you're?
No, I don't think that that's my dilemma. I think my dilemma is it appropriate to say, wait a minute, I'm just not going to take this at face value, right? I want to test this evidence. I mean, if I honestly believed that I was wrong, I don't think I would have any hesitation. But I basically am in a position where I'm not convinced that the new statement is accurate. It's I believe the old statement, based on all the stuff that we have. But I could be wrong. Peggy?
Although it's not admissible, would you ever consider asking the now 21 or 22-year-old to take a polygraph?
I don't think I probably would on this, basically on the situation that I don't like polygraphs to begin with. Secondly, it's obviously not admissible. And if she believes it herself, I don't know we would get an accurate statement. I mean, so I'm not sure that it would do us any good. I have, in fact, asked a professional to review the videotape of her statement and to compare it with the earlier statements and the testimony, the trial transcript testimony, because we've got that, right? We have all of that stuff, to give me a reading on what that person is thinking, and they think that this is not a true recantation. So, yes,
Were you the prosecutor in the original case?
I was. Yeah, it's been my case all along. And it was an interesting thing because it was primarily investigated in the state of Washington because that's where the mother and the little girl lived. So it was a Washington detective that I really didn't know, who brought the information to us through a referral after the child had shown up at the sexual assault clinic. They called the cops. And this is also a family that's incredibly dysfunctional family. It was just, as is so often the case in these things, nothing can make this right for a whole bunch of these people all the way around. Yes?
Absent the burglary charge, if she had recanted before the rape case went to trial, would you have been able to still charge the rape case?
I don't know. I think that that would have been a real difficult case to have proceeded. It was difficult enough even without her recanting, okay? The jury took a long time to return a verdict in that case. Mostly because the jury wasn't, not so much because they didn't think sexual activity took place, but they weren't sure whether it was rape or sexual assault. It was the issue of penetration, which is the only difference between when you're involving a child in a situation like that. And that's what seemed to take the jury a really long time to decide, based on the no medical evidence. So you just had the little girl's testimony that yes, he put something inside her. Right. And that's what we were doing. So, I suppose I would go through the same process I've gone through here, is to have someone else take a look at her and help me use a professional to try and help me decide. Plus, I need to rely on my years of experience too, and that's part of what we do. Okay, I guess I'll open it up for questions if there are. Yes?
It spins off of what case you just were talking about. Is it fair to ask the courts to decide the undecidable?
It's what we do all the time. Right, and and I don't know what other system we have that would allow us. I mean, none of us, I don't read minds, I don't have a crystal ball. We have to make the best decisions that we can based on the evidence. But yeah, you're absolutely right, that a court of law with evidence, from one side or another and cross-examination and those kinds of things is a very, sometimes awkward way to get at the truth.
Well, we know from the emerging DNA out of Chicago and other places where those things have been, that I think it's something like a 10% error rate or something. It's pretty significant. And so, the question comes up, are we, by pushing things beyond the envelope, what have we accomplished? And in other words, the horrible injustice that those people with DNA evidence didn't carry through, and the lack of confidence in the system,
right,
diminishes confidence in 12 men and women tried and true. That's starting to have its effect.
Well, and we certainly, obviously the thing that makes the system work is that we have confidence in it. If people really didn't trust the system, then who would abide by the rules and the law? You have to have that. And so for those reasons, the fact that we have improved our technology to a degree that we can have in some cases, things that help us know for sure, yes or no, involving people is wonderful. But unfortunately, the kinds of cases where that is true are very small. Like it would have done no good in this case, right? And in most cases, DNA evidence is just not available or recoverable as far as what we're going to do. So we still have to do the best we can. Yes?
When you were speaking earlier about the obligation that you have and the lack of reciprocal obligation to disclose information, the examples you gave with regard to the defense side involve privilege in the sense that it was a statement that was made by the client to the attorney, right, or by a patient to the doctor. If there is evidence that comes to the attention of the defense side, other than in a privileged situation, through some other means, do they have any obligation to disclose that to the prosecution?
Only if they're going to use it. In other words, if it's evidence that they intend to introduce at the trial, yes, they must tell us that. But if it is evidence that and a criminal defense attorney is not going to disclose evidence that hurts their case, right? So if they discover it, but it hurts their case, they decide they're not going to use it, then no, they don't have to turn it over.
Is that true in other places? I've heard of a notion that I think is fairly underdeveloped of reciprocal discovery, where there's an obligation on both sides.
We do have reciprocal discovery in Montana, and so anything that the criminal defense attorney wants to use in trial, they must turn over to me. So if they have to tell me who their witnesses are. Okay, and if they take statements from their witnesses, they have to give me copies of their statements.
But
they
only
have-
if they're actually going to use those statements?
Only if they're going to use the witnesses. Now, if they find witnesses that hurt themselves, let's suppose we have a case where it's an alibi, okay? And so the defense attorney is out interviewing people who supposedly support the guy's alibi. I wasn't there, I was over here at Joe's house, okay? Criminal defense attorney talks to Joe, and Joe says, no, he wasn't here, right? I hadn't seen him for 2 weeks, okay? Criminal defense attorney immediately knows that he's not using Joe, or, you know, he's not using this guy, and he doesn't have to tell me that he has found that out, okay? So, and that's the way the system works. So if they're going to use it, in other words, if they are going to have a psychological defense, and they've got a report from a psychologist that helps them, and they're going to call the psychologist, then they must give me a copy of the report, okay? But if they get a psych report that doesn't help them, they don't have to turn that over. Yes?
In the Missoulian, you see on a Monday crime report that there's a lot of drug dealers and meth manufacturers who get deferred or suspended sentences. It doesn't seem to make a lot of sense to me for you to go to all the trouble of prosecuting them if they're not going to spend jail time. I mean, can you tell me what's going on here?
Well, I think that we have to make some decisions here about, again, back to how to use most of what our resources are, and to figure out whether or not we can afford as a community to lock all these people up. Sometimes we make the decisions that financial punishment, which happens in these kinds of cases, and having them on supervision where they are monitored closely is a better use of our resources, because if they screw up on probation, then we don't have to go to the trouble of a jury trial to convict them. We just come in and we have a short hearing before a judge, and then they can go to prison. So sometimes it's the long view that we're looking at instead of the short view.
So most of these people would have pleaded guilty or had some...
Almost all of these people have pled guilty, and they've entered into plea agreements with the prosecutor in our office, so the two attorneys have discussed how to resolve. It's also true that most of these people do not have a prior record, okay, so that this is a first-time offense. And we know in this community that most judges, our judges, are not going to send people to prison if it's a first time, unless it's a really violent offense. I mean, that's a violent offense or an offense against a kid, you know. They typically don't go to prison on the first time around. I guess we're out of time, aren't we?
Yes.
All right.
Please join me